Hey everybody, News Now Wyoming. Today we are going to be discussing the case of Jack Miller versus a couple police officers. This, if you haven't seen the video yet, happened at the Walmart down in San Angelo. Police officers were responding to a call for somebody who appeared to be drunk and hassling other customers that had a young child with them. So I'm not going to go over the video of this. You can watch that on a few channels. I know Texas Sheepdog covered it. Justin Pulliam released a video last week, and so did Audit the Audit. Audit the Audit has a good breakdown of what the laws are. On his video, Justin Pulliam did a great release of just the whole body cam, so you can watch the entire thing. So check out those channels if you want to actually watch the interaction. Today we're going to go over this case filed in the Northern District of Texas, San Angelo Division. Comes now, Jack Miller individually and his minor son DM complaining of 3 stupid officers and for causes of action will respectively show unto the court as follows. On October 4th, 2020, officers wrongfully and illegally arrested Jack Miller, which is not Texas Sheepdog Jack Miller, in front of his 3-year-old son, DM, even though Mr. Miller had committed no crime. Officers Mayberry and Francis approached Mr. Miller inside a Walmart based on an erroneous call that a man with a child was intoxicated. Upon making contact with Mr. Miller, these officers concluded that Mr. Miller was not intoxicated and had committed no crime. However, in an act taken straight from a dystopian police state. Woo! I love that. Alright, you know what? Let's highlight mode. The officers demanded that Mr. Miller identify himself before he was free to go about his day. Excuse me. Officer Weber even went as far as threatening to call Child Protective Services to take Mr. Miller's son if Mr. Miller did not comply with their illegal demands to identify himself. Now, I do want to point out, in fairness to the police officers, it was not an illegal demand. They have every right to ask for an ID, just like I can walk up to anybody on the street and say, show me your ID. That person has a right to tell me to go to hell, but it is a legal request. Now, what they've done, it goes beyond that, but it is not illegal for them to ask for the ID. That is very typical with police officers. No matter what you've done or haven't done, what they are there for, they have to ID you because it just makes them feel better. They know that you are not drunk because they know who you are, I think, is the reasoning behind. I don't know. Honestly, you guys, it's the stupidest reasoning in the world. I don't understand it, but police think that they have to identify everybody, and they think that they have the right to identify everybody with force if necessary, which they do not have, especially there in Texas, which I think this lawsuit is going to talk about the law, so we won't go there. Mr. Miller did not become aggressive or combative, but simply asked why he needed to identify himself if he was not under arrest for anything, which is precisely what the law dictates. In response, the stupid officers illegally arrested Mr. Miller in front of his 3-year-old son without probable cause that any crime had been committed. DM immediately began crying in fear for his father as these officers called Mr. Miller a dumbass and assaulted Mr. Miller by unnecessarily pinning his neck against the top edge of a cooler and raising his handcuffed wrist behind his back till they injured his rotator cuff and his shoulders. The stupid officers then walked Mr. Miller outside to be placed in a police car as Mr. Miller's frightened and distraught 3-year-old son remained with Officer Weber, one of the men he had just watched assault his father. Mr. Miller now files his lawsuit against Officers Weber, Mayberry, and Francis for violating his constitutional rights under the 4th Amendment to the United States Constitution to be free from unreasonable seizures, falsely imprisoning him, and assaulting him, and for inflicting needless and damaging emotional distress on his 3-year-old son, DM, who is now scared to go to the store because he believes his father will be taken away by police. Parties. Jack Miller is a resident. Stupid cop. Stupid cop. Excuse me. Dog. Stay down. Stupid cop. Okay. The court has original jurisdiction. Don't really care about jurisdiction crap. Alright, facts and allegations. On October 4th, 2020, defendants, Officer Michael Weber, them, approached Jack Miller as he was shopping at Walmart with his 3-year-old son, DM. The interaction between Mr. Miller and defendants was recorded on his body-worn camera. Mr. Miller was about to check out with his groceries when they first approached him. Mr. Miller's 3-year-old son, DM, was sitting in the shopping cart along with Mr. Miller's groceries. Defendant Mayberry asked Mr. Miller if he had been drinking and explained that there was a reported call of an intoxicated driver with a child in the parking lot. Mr. Miller responded that he had not had anything to drink. Defendant Mayberry asked Mr. Miller if he knew anything about the report. Mr. Miller explained a woman honked at him in the parking lot as he was trying to park, and he told her that she couldn't drive, but nothing more had happened. It was obvious to defendants Mayberry and Francis that Mr. Miller had not been drinking alcohol and was not intoxicated as the original report claimed, as they told Sergeant Brian Holt later that day that Mr. Miller was not intoxicated. After speaking with Mr. Miller and determining that he was not intoxicated, defendant Francis asked Mr. Miller for his name. Okay, so as an aside, they were there to find out if somebody was causing a nuisance. No complainant stuck around to complain about the guy. So they had a very broad description. Male with curly hair and a child in the car. And that he was drunk. In a real world, real police officers, once they found out that he wasn't drunk, that he wasn't driving drunk, that should have been the end of the call. Okay, sir, thank you for answering our questions. Have a good day. It should have been it, if they talked to him at all. Now, he answered more than I would have. When they started asking questions, I would have said, kiss my ass. But he answered them very politely, clearly because his son was with him. I cannot fault him for that, and I will not fault him for that. Okay, so back to the story. Asked Mr. Miller for his name. Mr. Miller responded Jack, which is his first name. Defendant Francis asked Mr. Miller if he had his ID so that Defendant Francis could verify his ID. Mr. Miller responded that he had an ID, but he did not have to give the defendant officers his ID. Defendant Mayberry then told Mr. Miller, I don't think you understand what this is. This is not you get to tell us what is what. Defendant Mayberry told Mr. Miller, we are trying to identify who you are, and you are making that difficult. Yes, that is true. That is a true statement. And who cares about making their life difficult? That is not what the law does. Actually, what Mr. Miller was doing was attempting to go shopping with his son without having government agents force him to produce identification to verify his identity. So, any cop lovers that happen to watch this, tell me, what good would IDing him have done? What difference would that have made in any of this? What possible scenario would they have said, oh, no, you're not guilty of anything just from IDing him? I don't see it. You're not drunk because we know who you are now? You didn't verbally assault somebody verbally assault, sure, we'll go with that. I can't remember what terms they used in the video. But you didn't verbally assault somebody in the parking lot that didn't stick around to complain to us? Because now we know who you are. Yeah, that's logical. Mr. Miller calmly stated that he did not have to turn over his identification, which is exactly what the law states. He again asked from Mr. Miller for his ID, stating just to verify who you are. I want to verify who you are so you can go about your day and we can go about our day and we will be done. Okay. Then approached and asked if Mr. Miller was failing to ID. Told Defendant Weber that Mr. Miller was failing to ID. Then told Mr. Miller, unless you identify yourself with this legal investigation, you are going to be arrested for failure to ID. Now, I do want to point out, and I'm not certain on the rank structure, but this defendant Weber had 2 stripes on his shoulders. So most police departments, that's like a corporal. That's training officer type of rank, right? This is the person that trains everybody else underneath them. This is the person that is the first supervisor on site most of the time. The sergeant will sometimes come to the scene, but a corporal comes to most scenes. That's important. This dumbass doesn't know the laws that he was hired to enforce. Okay, this dumbass here. Mr. Miller attempted to respond, but Defendant Weber raised his voice at Mr. Miller, stating, "Listen to me." Defendant Weber then told Mr. Miller, "And then we're going to call CPS, Child Protective Services, to come pick up your child." So he was threatening to have Mr. Miller's 3-year-old son, who was sitting within earshot in the grocery cart directly next to Mr. Miller, taken away from him if he did not identify who he was, despite the fact that Mr. Miller had not committed any crime and was not under arrest. Mr. Miller asked Defendant Weber if he was threatening to take his son. Defendant Weber again interrupted Mr. Miller. Mr. Miller asked if he was allowed to talk. Defendant Weber told Mr. Miller, "You have one thing to respond with right now, and that's to ID yourself." Again, Mr. Miller had not violated any laws, and the defendants had no probable cause that he had committed any crime. As defendants later told Sergeant Holt later that day, they did not have probable cause that Mr. Miller had committed any crimes. Mr. Miller tried explaining to Defendant Weber that failure to ID is when you have been lawfully arrested. Okay, so Defendant Weber then stated that Mr. Miller was being arrested. "Oh, you want to play it that way? Okay, well, we will arrest you." The handcuffing and use of force that is about to be outlined occurred within feet of Mr. Miller's 3-year-old son, DM. DM watched in horror as the defendants grabbed, pushed, and shoved his father. Defendants Weber, Mayberry, and Francis all grabbed Mr. Miller. Defendants Weber, Mayberry, and Francis turned Mr. Miller around so they had access to his hands to handcuff him behind his back. Mr. Miller did not resist the officers and complied with their instructions. Mr. Miller stated, "My kid is right there." Defendant Weber told Mr. Miller, "Turn around and put your hands behind your back," even though Mr. Miller had already turned around and his hands were behind his back. Mr. Miller stated that his hands were behind his back. And this is all in the video. It's very clear in the video. DM began to cry as the defendants appeared to be hurting his father. Mr. Miller calmly stated, "Look what you're doing, man," as his son was crying next to them. Mr. Miller tried to calm his son down by stating, "Baby, it's okay." Defendant Francis used his forearm to push Mr. Miller's face and neck up against shelving next to them, which was unnecessary as Mr. Miller was not resisting and Defendant Weber was placing the handcuffs onto Mr. Miller's hands, which were both behind his back. When Defendant Francis pushed Mr. Miller's face and neck against the shelving unit, it caused Mr. Miller pain and he could be heard groaning in pain. Sorry, you guys, my dog is over here making all kinds of mess. Face and neck against the shelving unit, it caused Mr. Miller pain and he can be heard groaning in pain. DM watched this happen. Mr. Miller calmly asked, "What are you doing?" Defendant Weber stated you have been placed under arrest for failure to ID. Defendant Weber then stated over his radio, "We have one resisting," even though Mr. Miller was clearly not resisting arrest as he was standing against the shelving unit with his hands behind his back as handcuffs were being put on him. Mr. Miller continued trying to calm down his son. After securing Mr. Miller in handcuffs, Defendant Weber called Mr. Miller a dumbass. Mr. Miller responded, "Dumbass, are you kidding me?" They then pushed the handcuffed and non-resistant Mr. Miller into a large drink cooler. Defendant told Mr. Miller to calm down, even though Mr. Miller had been calm the entire time the defendants had been assaulting and falsely arresting him directly in front of his 3-year-old son. He was holding Mr. Miller's handcuffed wrist behind his back and forcing him against the drink cooler. Defendant Weber had a hold of the back of Mr. Miller's head and was forcing his neck against the top edge of the drink cooler. They had a hold of Mr. Miller's right shoulder and the top of Mr. Miller's head and was helping force Mr. Miller against the drink cooler. Mr. Miller could be heard groaning in pain as the defendants had him pressed against the cooler, and Defendant Weber was forcing his neck against the top edge of the cooler. Defendant Weber was choking Mr. Miller by forcing his neck against the top edge of the cooler. He was not resisting, was handcuffed with his hands behind his back, had been calm the entire time, and was not attempting to escape or evade arrest, as his 3-year-old son was there with him. He then asked Mr. Miller if he was going to ID himself. Mr. Miller stated that he would give him his ID. Then Defendant Weber stated, "It's a little late for that, isn't it?" Mr. Miller stated that he was just now under arrest. Defendant Weber had a hold of Mr. Miller's left arm, which was pulled behind his back in handcuffs. Defendant Francis had a hold of Mr. Miller's right arm, which was pulled behind his back in handcuffs. Defendant Mayberry had a hold of Mr. Miller's hands, which were behind his back in handcuffs. All 3 defendants raised Mr. Miller's up and behind his back, causing his shoulders pain and injuring his rotator cuff. When all 3 defendants raised Mr. Miller's arms, causing him pain in his shoulders, Mr. Miller was not resisting, attempting to flee, or a threat, as he was handcuffed with his hands behind his back, being held by 3 officers who were all larger than him, had a calm demeanor which he had the entire time, and had his 3-year-old son present and watching. All 3 defendants held Mr. Miller in the position with his arms handcuffed and lifted behind his back, even though it was unnecessary, as he was calm, compliant, and restrained. Mr. Miller was asking the defendant where his son was as they held him in a painful position. They walked the handcuffed Mr. Miller out of Walmart into a police car. As they passed DM, Mr. Miller told his son that it would be okay. DM was scared while he was forced to wait inside the wall of the Walmart with Defendant Weber just after having watched Defendant Weber assault his father. Also, you guys, the kid was in the hands of a Walmart employee that the father did not know. I do believe Walmart should be culpable for some of this. Don't know how much, but I kind of wish that Walmart was added to the defendants list. I understand why the city is not, and we'll get to that at the end. Defendant Mayberry placed a handcuffed Mr. Miller into the back of a police car. Sergeant Holt arrived, and Mr. Miller explained to him that he had been arrested for failing to ID himself, even though he was not under arrest at the time his ID was requested. He then asked Defendant Mayberry and Francis what happened, and they confirmed that Mr. Miller was not under arrest when he was asked to ID himself. After discussing with Sergeant Holt, they told Sergeant Holt that they did not have probable cause that he had committed any crime. So they directed him to release Mr. Miller. Now, this is very important. Between this paragraph and this paragraph is about 5 minutes. About 5 minutes that Sergeant Holt, and you can watch in the video again. I had watched the video released by Justin Pulliam last week, and in the full video, he tries, man. He's like, "Oh crap, we just got ourselves in trouble here. Is he drunk? No, he's not drunk. Is there anything else?" I mean, he tried for about 5 minutes to find a way to keep the guy under arrest. He did. Did anything come up on the warrant? No. This is a law-abiding citizen. Crap. And you could see it in the sergeant's face the whole time. He's like, ever since they said he was put under arrest for not IDing himself. Thank God the officer, this sergeant, actually knew what the law was and enforced what the law is. Now, he did have a female officer who was not named in this and did not do anything wrong, in my opinion. He had her look up the law and read it out loud. And so there in the video, you read what exactly the law says. So it's very clear. Now, why did this two-striper not know that law? Why does he have to be taught on the spot? And then as well, the sergeant tells them, explain to him that this was just a misunderstanding of the law and just cop speak to him. Now, when he was out of his handcuffs, Mr. Miller, he went to go get his son. So this part had my, this was my favorite because he acted just like me. Am I under arrest? No. Do I have to do anything else? No. the cops were trying to cop-splain to him. They were trying to say, we are the good guys here. We did nothing wrong. You should always ID yourself, blah, blah, blah. They tried to cop-splain to him, and he said, shut the F up. I'm going to go get my son. Leave me the hell alone. And so he just walked away from him. And then, as he's walking away, the officer goes, yeah, you're free to go. Like he was going to stop for them. I mean, it was hilarious. Watch the video. Especially that part of it. You're free to go. Like, shut up. He clearly knows what the law is. He knows that you had nothing. He tried to tell you had nothing, and you wouldn't listen to him. So, stupid cop. Okay. All right. Since this incident, Diem has been terrified to go to the store because he believes the police will show up and take his father away. Diem used to enjoy playing cops and robbers, where he would be the police officer trying to catch the bad guys. However, since this incident, Diem has not wanted to play cops and robbers anymore, and if he does, he now wants to be the robber as he is scared of the police. So when he played it before, did he use a stick to beat anybody with? Or how do we teach kids how to play cops and robbers in 2020 or 2021? I don't know. Honestly, I never let my daughter play cops and robbers. I let her play cowboys and Indians or other stuff, but cops and robbers, that would imply some part of respect. And why would you teach your kids that? There's 1 out of every 10 cop is a good cop. That's what it is around here. I can't say that for everywhere, but and those other 9 cops don't stop the bad cop from misbehaving. So, yeah, no, this fear mental anguish that 3-year-old Diem was experiencing and continues to experience was directly caused by being feet away and watching as the defendants detained his father in handcuffs, assaulted him against the shelves and cooler, and then took him away. At all times relevant to this lawsuit, they were acting under color of law. Unlawful arrest, count 1, violation of the 4th Amendment pursuant to 1983 against the stupid defendant police officers. He repeats everything he just said up above. No right is held more sacred or more carefully guarded by the common law than the right of every individual to the possession and control of his own person, free from all restraint and interference of others, unless by clear and unquestionable authority of law. Terry versus Ohio. I pulled a couple others more sacred, but it's pretty sacred and it's pretty well established. Okay, they deprived him of his constitutional and protected right to be free from unreasonable seizures under the 4th Amendment by unlawfully arresting him despite lacking probable cause that any crime had been committed, as he was not under arrest at the time he was asked and then refused to ID himself in a committed crime. It shows under 1983 showing of willful detention without consent. Yeah, that's pretty clear from the video. Without authority of law, we'll talk about that in the paragraph. The deprivation of a constitutional right. There is no cause of action for false arrest unless the arresting officer lacked probable cause. There can be no doubt that the right not to be arrested absent probable cause was clearly established at the time of Mr. Miller's arrest. They only state one case from 2017, but there is a lot of case law on that particular point. So, clearly established that you have a right not to be arrested absent probable cause. That's a very, very clearly established law. Fifth Circuit case law also is clearly establishes that police officers lack actual or arguable probable cause to arrest a person for failure to ID in violation of Texas law when the person has not been arrested at the time that he fails to provide officers with identification, because the failure to ID offense is triggered only when a person who's already been arrested fails to provide identification upon an officer's request. Now, Texas is very, very, their law is very clear on this. That you only have to identify yourself after you've been arrested. Very clear on that. Now, other states, not so much, and it's more ambiguous, right? Missouri, where I was asked for an ID, you have to ID yourself if you've been suspected of a crime, but you only have to provide your name and address. Don't have to provide an actual physical ID. Nothing in the law that says that. Here in Wyoming, I still can't find any statute here in Wyoming that requires you to identify yourself under any reason unless you are driving or carrying a concealed weapon. That's it. I can't find any statute that requires it. Now, it's probably a good idea if you've been arrested to go ahead and give them your name, but I can't find any code that says you have to. And I have done some searching. Every state is different, though. So know what the law is in your state. This guy knew what the law was in his state. To determine the presence or absence of probable cause, the totality of the circumstances surrounding the arrest must be considered. The stupid defendants intentionally arrested Mr. Miller by restraining him in handcuffs and later confining him to the back of a police car without a warrant, without his consent, and without any legal justification. He did not consent to his restraint or confinement and was conscious of both. He stated it. The stupid defendants willfully arrested plaintiff by telling plaintiff he was arrested and by restraining plaintiff in handcuffs and later in a patrol vehicle. He did not consent to being restrained in handcuffs or to being restrained in the patrol vehicle. Stupid defendants did not have probable cause to support arresting Mr. Miller, as they did not see Mr. Miller commit a crime and he was not under arrest at the time he refused to identify himself. Thus, the failure to identify offense, under 3802, was not triggered since it applies only when an officer has lawfully arrested the person and requested the information. Texas Penalty 3802A. Additionally, stupid defendants admitted to Sergeant Holt they did not have probable cause to arrest Mr. Miller for any other crime. Defendants Mr. Weber's stupid defendants did not have authority of law to arrest Mr. Miller as they did not have a warrant of probable cause. Sorry, you guys, this is already almost 30 minutes. I thought this would be a total of 30 minutes. And no other exigent circumstances existing justifying his arrest. By knowingly and intentionally arresting Mr. Miller without consent, without probable cause, and without legal justification, defendants Weber, Mayberry, and Francis deprived Mr. Miller of his Fourth Amendment right to be free from unreasonable seizures. As a result of the illegal arrest, Mr. Miller suffered injuries. As a result of the illegal arrest, the stupid defendants deprived him of his civil and constitutional and statutory rights and are liable to Mr. Miller pursuant to 1983. Mr. Miller was damaged as a result of stupid defendants' wrongful acts as his liberty was deprived and he suffered the emotional distress and mental anguish of seeing his son cry out in fear. Additionally, when making the illegal arrest, the stupid defendants injured his rotator cuff, causing him physical pain and suffering. Count 2, excessive force, a violation of the Fourth Amendment, according to 1983. Mr. Miller repeats and relays everything up above. Acting under the color of the law, the stupid defendants deprived Mr. Miller of his rights and privileges and free to be from illegal and unreasonable seizures by the use of force. He brings his case, the amount of force used by stupid defendants, as described above, specifically but not limited to, when the stupid defendants slammed the already handcuffed Mr. Miller against the drink cooler. Stupid defendants pressed his head and neck against the top edge of the cooler, and then stupid defendants raised his arms up behind his back and held him in that position until his rotator cuff was injured, was objectively unreasonable under the circumstances and inflicted unnecessary injury, pain, and suffering upon plaintiff. A seizure is unreasonable if it results in a injury that resulted directly only from a use of force that was clearly excessive, and the excessiveness was clearly unreasonable. Although stupid officers may need to use some physical force to effectuate suspect's complaints when he refuses to comply with commands during a traffic stop, the officers still must assess the relationship between the need and the amount of force used. Where an individual's conduct amounts to mere passive resistance, use of force is not justified. A constitutional violation occurs when an officer tases, strikes, or violently slams an arrestee who is not actively resisting arrest. Fifth Circuit case law makes clear that when an arrestee is not actively resisting arrest, the degree of force an officer can employ is reduced. Mr. Miller was not suspected of committing a felony offense when defendants Weber, Mayberry, and Francis slammed him against the drink cooler, when defendants Weber and Francis pressed Mr. Miller's head and neck against the top edge of the cooler, or when the stupid defendant injured his rotator cuff by raising his arms up behind his back and holding him in that position. Mr. Miller was only suspected of committing a minor offense for failure to identify, which he had not even committed. Mr. Miller was not attempting to flee, as his 3-year-old son was with him. He was in handcuffs being held there by 3 officers, and he was calm and compliant the entire time. Mr. Miller was not threatening any officer or other person immediately prior to when the stupid defendant slammed him against the drink cooler, when the stupid defendant pressed his head and neck against the top edge of the cooler, or when they injured his rotator cuffs. Mr. Miller was not resisting arrest prior to when the stupid defendant slammed him against the drink cooler, when stupid defendants pressed Mr. Miller's head and neck against the top edge of the cooler, or when the stupid defendants injured his rotator cuff by raising his arms up behind his back and holding him in that position, as he had complied with the defendants by turning around and putting his hands behind his back to be handcuffed, and then took a couple steps with the defendants before they slammed him against the cooler for no reason. A reasonable officer would know that the use of force is clearly excessive when engaging with citizens such as Mr. Miller, who was not threatening any officer or other person, was only suspected of committing the misdemeanor crime of failure to identify, which had clearly not been committed, was not attempting to flee, was not resisting arrest, but the use of force was not warranted. A reasonable officer would know that the use of force is clearly unreasonable when engaging with citizens such as Mr. Miller, who was not threatening blah blah blah. A reasonable officer in stupid defendant's shoes would know that slamming a person against a drink cooler, pressing their neck against the top of a cooler, then raising their arms up behind their back and holding them in that position till their rotator cuff was injured, when that person was not threatening any officer or other person, was only suspected of committing the misdemeanor crime of failing to identify, was not attempting to flee, was not actively resisting arrest, is clearly unreasonable and excessive. As a direct result of him by the stupid defendants, he has suffered physical injury, pain, and mental anguish, for which he sues the hearing. Now, he is asking for help. I do know I sought a GoFundMe to help pay for a scan of his rotator cuff to find out exactly what injuries, because he hasn't been able to afford to go get that done. So you can search for Jack Miller, San Angelo, GoFundMe, and you can find it in there. Count 3, false imprisonment against the stupid defendants. He repeats and realleges each and every allegation. The elements of false imprisonment under the Texas state law: willful detention by the defendant without consent and without authority of law. The stupid defendants willfully detained Mr. Miller by imprisoning him when they restrained him in handcuffs and placed him in a patrol car. Mr. Miller did not consent to being imprisoned, being restrained in handcuffs, or being placed in the patrol car. The stupid defendants did not have authority of law to imprison him, as they did not have a warrant or probable cause to arrest him, and no other exigent circumstances existed justifying his arrest. The stupid defendants did not have probable cause to support arresting Mr. Miller, as they did not see Mr. Miller commit a crime, and he was not blah. Okay, there's no justification. Assault. He repeats and realleges every allegation as follows: slamming and pressing him against the cooler. We've read about that already. The stupid defendants again. Choking him. He's saying that when they pressed his head and neck against the top of the cooler, it was choking him and recklessly caused bodily injury to him. And then the injury to his shoulder by raising him up with his hands behind his back, which I got to admit, that would hurt. Bystander recovery. Mr. Miller, on behalf of the DM, repeats and realleges each and every allegation contained in the above paragraphs, incorporates those allegations in this count, and further alleges that to recover as a bystander, a plaintiff is required to establish the plaintiff is located near the scene of the accident, as contrasted with one who is a distance away from it. Yep, he was right there in the shopping cart. The plaintiff suffered shock as a result of a direct emotional impact upon the plaintiff from sensory or contemporaneous observance of the accident, as contrasted with learning of the accident from others after its occurrence. Yeah. The plaintiff and the victim were closely related. Yep, he was his father. So I'm just going to stipulate that yes, all those things were true. He was right there. It repeats and alleges when the viewed objectively from the objectively from the standpoint of stupid defendants, at the time of the occurrence, said defendant's conduct involved an extreme degree of risk, considering the probability and magnitude of the potential harm to others, as a direct, proximate, and producing cause, and the intentional, egregious, malicious conduct by defendants, stupid defendants, was recklessly and callously indifferent to his protected rights. He individually and on behalf of DM is entitled to recover punitive damage in an amount within the jurisdictional limits of this court. He individually and on behalf of DM repeats blah blah may recover directly damages directly related to the invasion of their privacy. His injuries were foreseeable events. Okay. Anything else here important enough for this video? The kid was forced to suffer emotional distress, torment, and mental anguish in the past and future. They request the award of exemplary and punitive damages, reasonable attorney fees, and costs of court. He prevails in this action. He is entitled to and hereby demands attorney fees. He individually and on behalf of DM respectively requests a jury trial, where for premises considered, Mr. Miller individually and on behalf of DM prays that the judgment be rendered against the defendants for an amount in excess of the jurisdictional minimum of this court. Mr. Miller individually and on behalf of DM further prays for all other relief, both legal and equitable, to which he may show himself justly entitled. Now, he did not sue the city. Look, if we come back up here to the top, he only sued the stupid defendants, right? Only the 3 officers. Didn't sue the sergeant because he did good. Even though he tried to jam him up, he did good in the end. He didn't sue that female police officer whose only crime was pulling up and then reading the law when asked by the sergeant. She did good. She didn't stop them from doing anything, but she was outside the store and didn't see it. So, questionable, right? Alright, so why should the city be sued? Because these 3 officers are still employed by San Angelo, I'm sorry. They are still employed. They are still working for that police department. Until cities and police departments start recognizing that this type of behavior is unacceptable, they should be added to every lawsuit against their officers, as long as that officer still has a job at that department. And not don't give them an offer, chance to resign. Fire their ass. Fill out that paperwork for dishonorable. I don't know what it is in Texas for officers. Every state is different there too. But I do know that here in Wyoming, if you are fired as a police officer, they can fill out a form and you are dishonorably discharged as a police officer, and you cannot be hired by another police department or law enforcement agency here in Wyoming. But if you're allowed to resign, you can go work in the next city over or the next county over. Or, because these are police officers, I don't know if San Angelo is a county or what county this is. Let's pretend San Angelo itself is also a county. They could go get a job in that same city for the sheriff's department if they're allowed to resign. They can still terrorize the same people that they were allowed to terrorize right now. So yes, I do think that right here, let's just add in city of San Angelo, right? Let's just do that. Let's just add them in there. In fact, can I grab a hold of that? And let's put you top. Let's just change that a little bit. Nope. I don't know how to make that bold, but that's alright. You guys get the drift. Let's go ahead and write in the city of San Angelo there. They should be sued until they fire those cops. Because until they fire him, they are telling every police officer under their control that this is acceptable behavior, and the worst you might get is a suspension. That is unacceptable. Go out there, reach out to this police chief. He's already put out an apology for this. He's already admitted wrongdoing for his officers. That's not good enough. They should not have a job. They should be fired. All right, you guys, so thank you for joining. Here we talked about Jack Miller versus the three police officers there in San Angelo, arresting somebody at Walmart for failure to ID themselves. No other crime. Thank you guys. Have a great night.